Good afternoon, students. My name is Indira Priyadarshini Pradhan, Assistant Professor, School of Management, IMS Ghaziabad, University Courses Campus. Today, I am going to discuss about the most important act in industrial labor law, that is Industrial Dispute Act 1947. Before moving further, we need to learn about the learning outcome after completing or understanding the topic Industrial Dispute Act. So in this topic, after completing, the student will be able to understand about the importance of Industrial Dispute Act 1947, and the student will be able to understand about the various way of settlement of industrial disputes. Student will be able to understand about the prevention of illegal strikes and lockout. So what is Industrial Dispute Act? Industrial Dispute Act is an important legislation in India that deals with the resolution of dispute and grievance between employer and employee, between employees and employees, and it can be between the employer and employer in industrial establishment. The act was first enacted in 1947 and has been amended several times over the years. But the main objective of this act is to ensure the settlement of dispute and to maintain the industrial peace and harmony. The key objective of this Industrial Dispute Act is to promote the industrial harmony, is to prevent the dispute, and it's to prevent the strikes and lockouts. It's to give a good relationship between the employer and the employee. So this act also first provide for the appointment of conciliation officer who are responsible for the mediating between the parties and trying to resolve the dispute through negotiation. What is this conciliation process? Actually, for Industrial Dispute Act, there are 5 authorities are there to resolve the dispute. The first is conciliation officer. The second is board of conciliation. Then the third is labor court. Then the fourth is industrial tribunal, and then is the national tribunal. Right? So under this Industrial Dispute Act, several authorities are responsible for the settlement of industrial dispute that I have already discussed right now. Right? So if the conciliation fails, the dispute may refers to the labor court, the industrial tribunal, or national tribunal, depending on the nature and the complexity of the dispute. So what is a conciliation officer? A conciliation officer is appointed by the appropriate government to mediate and bring about the settlement between the parties in case of any industrial dispute. So next, what is a board of conciliation? So if the conciliation proceedings fail, that is the process that has been taken by the conciliation officer, if it fails, then the appropriate government. So what is appropriate government? So in case of state, it is the state government, and in case of central, it is the central government. Then that means the appropriate government may refer the disputes to the board of conciliation consisting of a chairman and 2 or 4 members which represents the employer and employee respectively. Then the next part is the labor court. If the dispute that is arises, that is fail in the conciliation officer, then in the level of board of conciliation officer, then it moves to the labor court, and again the labor court is referred by the appropriate government, which consists of a single judge. Then the industrial tribunal. So what is an industrial tribunal? Industrial tribunal consists of it is constituted by the appropriate government which adjudicate on industrial dispute. That means the disputes which are fail to conciliate in the conciliation level, then the board of conciliation level, then again with the labor court. Then the appropriate government may refer the case to the industrial tribunal. Right? So what is industrial tribunal? So industrial tribunal that consists of a chairman and 2 or 4 members which representing the employers and the employees respectively. That means from the 2 or 4 members, some 2 members are from the employee side and 2 members are from the employer side. Then if the case fails to resolve in the case of industrial tribunal, then the case is the dispute is referred to the National Tribunal Court, which is again by the appropriate government. Right? If the disputes that involve the questions of national importance or it affect the industrial establishment in one or more state, then definitely the case or the dispute is referred to the National Tribunal by the appropriate government. Next, there are another types of another court or another type of resolving the disputes in the industry, that is arbitration, voluntary, right? So that means arbitration is a voluntary process where the settling or difference between worker and the management with the advocacy. That means it is by the voluntary choice, the worker and the management have their own persons, they advocate the disputes and they try to settle without moving to the labor court or to the industrial or to the National Tribunal Court. Right? So on failure of this conciliation proceeding, the conciliation officer may pursue the parties. That means they refer the party to dispute to a voluntary arbitrator. Before moving to the court or anywhere, the conciliation officer always prefer or always ask the management to have a voluntary arbitration between the parties, right? So this way the dispute may settle through an independent person chosen by the party or that is involved mutually and voluntary. So most accepted or the appropriate way of handling any dispute is the arbitration way. There both the party, that means the management and the employee, they may not go to any legal process. They have their settlement mutually and that is voluntary.